Well, today I'm going to be talking about the innovation patent process, how they're different to standard patents, and what the benefits of filing an innovation patent are. Firstly, a few key differences between the innovation patent process and the standard patent process. An innovation patent lasts for 8 years, and a standard patent lasts for 20 years. So why would you file a patent application that lasts less than half the length of time of a standard patent? Well, an innovation patent is much easier to get. To get an innovation patent, you only have to fulfill 2 criteria. The idea needs to be new and innovative. But what does innovative mean? It's a pretty subjective test. Well, for an idea to be innovative, it basically just needs to be different to what has come before in terms of the way it works. An innovation patent is relatively easy to get. That's the first advantage. Secondly, an innovation patent is fast to get. After you've filed an innovation patent, it generally proceeds to grant within about 3 months. And thirdly, innovation patents, being limited to 5 claims, are generally cheaper to draft and so less expensive to file. So, how are innovation patents used practically? Well, if you have an invention that you're concerned is not non-obvious over what's come before, then you may have no choice. An innovation patent is your logical fallback position. Secondly, innovation patents are used a lot in litigation. So if you have your standard patent proceeding through the process and you notice someone infringing that patent, well, instead of contesting the infringement on the basis of your standard patent and therefore putting the validity of your standard patent at risk, you can file a divisional innovation patent. So it works something like this. You file your standard patent application and it's proceeding through the process, the normal process of examination, acceptance, grant. Now, at some point after you've filed your standard patent application, you notice an infringement. Someone's copying what you've described in your standard patent application. So what you can then do is file as a child application, we call it a divisional patent application, a divisional innovation patent. And the 3 key advantages of filing a divisional innovation patent in this type of situation are that, firstly, it's more difficult for the other side to invalidate. So you're accusing another side of infringing your patent, and they, in turn, will try to have your patent revoked under normal circumstances. And given the innovation patent only needs to be new and different in the way it works from prior art, it's pretty hard for the other side to invalidate the patent on either of those 2 grounds. This, of course, compares to invalidating a standard patent where you'd have to show that the idea was in fact obvious. So the second advantage of filing an innovation patent in litigation is that it proceeds very quickly to grant. To get from your innovation patent filing through to grant and then examined and certified can all be done in a matter of just 6 months. And thirdly, of course, the innovation patent process is relatively inexpensive. So in this way, you can use innovation patents to get a strong, enforceable right without risking your main patent family. And that, I think, is the key benefit of innovation patents.